A Washington state judge dismissed my case against the Department of Natural Resources in Washington. Many of you who have been following for a while know that I filed a lawsuit against the Department of Natural Resources in Washington and several of the executives there because I was fired for refusing to censor doctors and scientists on this podcast during COVID. They said that the interviews I was doing with some of the best doctors and scientists in this country, frankly, were undermining their vaccine mandate, and they demanded I stopped. I refused. I said I had a First Amendment right to continue. It was on my personal time using my personal equipment. And I told them the government had no right to tell me who I could talk to or what those people could say on my off time. They disagreed. They fired me. The Silent Majority Foundation represented me and filed a lawsuit for First Amendment and 14th Amendment claims. And the Judge Tiffany Cartwright, decided with the state, in favor of the state, that my lawsuit should be dismissed. They argued that my attorneys missed the statute of limitations by really a couple days. So it really came down to the wire. And the state had one interpretation of the statute of limitations. My attorneys had a different interpretation of the statute of limitations. The judge decided in favor of the state. I have lead attorney Pete Serrano here to talk about this and explain what happened. If you want to read the documents for yourself, you can go to silentmajorityfoundation.org. It's very easy to find my case in particular. All of the documents are up there so you can read it for yourself and decide for yourself. I will say before we get started with Pete that some people said, well, I'm not surprised. Washington has not shown itself to be in favor of the Constitution for a long time. So while I feel bad for you, I'm not surprised by this. Frankly, I am very surprised. I was shocked when I found out. I did not think that it was going to end this way. I actually thought we would prevail. I was fascinated by the whole case itself. One of the main reasons that I decided to file, not just because of justice, was because I really wanted to see how this all worked. I wanted to argue this case because I firmly believe that the Constitution is the most important document we have for this country to run our government, and that our government has run amok on the Constitution. So just being able to see how the court would interpret my claims about my rights to speak as a government employee on my own time, I wanted to be able to tell you all about what that was like. I wanted to see it firsthand. That's one of the things that I loved about being a journalist when I was in television news, was just being able to see firsthand what other people were reading or watching on television. I wanted to see it for myself. And so I'm frankly, I am shocked. I'm disappointed we don't get to argue these facts before a court and see what they would have decided, whether we went to a jury trial or just had the judge presiding over it. I wish we could have seen what they would have decided. Even if it didn't end up in my favor, I would have liked to see how they would have argued that I didn't have the First Amendment rights that I claim that I do. So, you know, all I can say, because I really still to this day, I'm kind of speechless as this is how it ended, is I just really cannot thank the people who have supported me enough through this whole journey, whether you gave to the Give, Send, Go, that bought our groceries, that gave me the time to go through all these documents and give them to my attorneys so that we could comb through what I still had in my emails, so that I could pay a babysitter to give me the time to do that, to keep the lights on in the studio here. You all have really proven that someone can choose a path of righteousness at great cost, and that God will provide. And that is my greatest takeaway from all of this, is that you can choose courage and you can choose the path of righteousness at great cost. And there will be a God there to take care of you and people there who will come to your aid. So thank you to everybody who has shown me that has been a great growth experience from my own faith. And I really appreciate all of you. I will say that if you are sitting here and you're thinking, well, on top of growing my faith, maybe I also just want to have a good glass of wine at the end of this interview, because, usually I tell you guys, you might need a drink to get through the interview, but I might need a drink to get through the interview too. So go to AllisonWinePromo.com and join my wine club. You will get 6 bottles of amazing wine every 3 months. They will come to the mail for you. You don't have to order them, and you'll have them for gifts, for holidays. They're all selected for the kinds of wines that I really like, which are handcrafted, hand-picked grapes in many cases. Some come from between 6,000 and 9,000 feet. Vineyards that have been around for hundreds of years, fifth family generation, winemaking techniques, and really unique wines that you really cannot get anywhere else. They're all the kinds of wines that I like. I clean my house with vinegar. I brush with fluoride-free toothpaste. I'm not going to drink a crappy wine that's going to give me cancer. And this is the kind of wine that I like. So if you like the kind of wine too, go to AllisonWinePromo.com and join my wine club. Thank you so much to everybody who supported the sponsors and has stuck with me through this crazy few years. Okay, I'm going to bring in Pete. We're going to discuss the lawsuit. Pete, thank you so much. I'll just introduce you for people who are not familiar. Pete is the lead counsel and the founder of the Silent Majority Foundation and represented me, filed my lawsuit for me, and I think wrote up a great case. And unfortunately, a technicality got us, stuck in this situation where basically, Pete, correct me if I'm wrong, but the state was arguing that I should pay their attorney's fees. We discussed whether I should appeal. You all felt that an appeal was not going to get me anywhere, and then I could potentially be, liable for upwards of $50,000, $60,000 or more in attorney's fees paid to the state. So we decided that I would drop the case so that I wouldn't have to pay that money. That's what I remember happening. You tell me why we ended up deciding we weren't going to go forward with an appeal.
Yeah, so that's a great summary. I'm going to walk back and just kind of fill in a couple of the gaps of where you started, what I picked up. We started the case, and really what the technicality that Allison mentioned that had this case dismissed was the question of whether or not we should have filed on September 11th or September 14th. And it had to do with a couple of dates associated with meetings with HR, amongst HR and Allison, and amongst, trying to figure out when she actually was operatively, the state determined that she'd actually operatively been fired. And that's the craziest part about this is Allison had requested a robust volume of documents and got a handful. Her employment file, if I recall, was like 25 or 30 pages. And in those couple of pages was a memo that Allison had written, putting this timeline forward, and the judge hung her hat on that timeline. Now, these aren't documents of, Allison's supervisor to that person's supervisor saying, hey, we're going to terminate her. It's Allison's understanding of the process that really got this 11th date versus the 14th date as the operative date. And to me, that's where, when we looked at this, we said, no, the actual decision that came down from HR, we brought it in as a piece of evidence, and the operative date there should have been no later than October 13th or October 13th or October 14th. And when we filed, it would have been timely. To Allison's point earlier, it was literally 2 days. So fast forward, we litigate the case. The state brings what's called a motion for judgment on the pleadings. It's a motion to dismiss. Now, interestingly, at this point in the case, this type of motion, a motion to dismiss, you're supposed to accept the complaint as pled as the true facts. You get to litigate that down the road, either before a jury or through further discovery. You can kind of finagle the 11th was operative date, or the 14th or the 13th was the operative date. That's down the road. It should have been accepted as true. At that point, it seemed that it was reasonable that filing when we did was timely. And when we saw the motion for judgment on the pleadings, the motion to dismiss, we thought, this is crazy. There's no way there's success. And obviously the judge disagreed with us. And so kind of fast forward to the end of the story, when the judge did agree with the state that we should have filed on the 11th, having missed the statute by just a few days. One, obviously, there was a lot of shock and surprise because, again, the only thing that indicated the 11th was an important date was Allison's own email. The documents from the state said the 13th or the 14th. And even at that point, we still believe there was an open question as to whether or not Allison was going to be terminated. Again, obviously don't want to relitigate the case in front of your audience, but that's the craziness of how this ends. And to your point, we looked at, all right, what's our path forward? the judge gave us an opportunity to modify the complaint on what's called a name clearing basis. In other words, Allison wasn't granted a post termination hearing that would have allowed her to clear her name of any, bad press, if you will. Obviously, they terminated her for free speech, and obviously, if they would have said otherwise, then that would have been a whole nother lawsuit. But so that was the concern there. We thought about that. It just seemed like it really watered the case down, and it was kind of a coin toss at best, going before the same judge with kind of a new claim. Obviously, she took a very narrow reading on the whole of the case. So to take an expansive or a solid reading on that issue just didn't seem like there was really an opportunity for success. And then, as Allison mentioned, the other two options were to dismiss the case voluntarily, make sure that there were no attorney's fees assessed against her, which, there would have been attorney's fees for this part. And then had we appealed and lost, there would have been attorney's fees compounded on that. That didn't seem like the right solution. And especially since we're in the Ninth Circuit, which, there are some good judges, but I'll just say it's not the majority. So it felt like it was a real long shot. And what we didn't want to do is incur additional expenses towards Allison.
There were a couple other arguments from the state that I want to get into in a second. Besides the statute of limitations, they also were talking about misclassified at-will employee, and now asserts a due process claim, right? Like you were bringing up the name clearing hearing. So they're arguing that. But then they're also saying that the state of Washington is protected by sovereign immunity. So I want to ask you about that in a second. But I do want to bring up a question that somebody asked on Rumble. How did you get so close to the statute of limitations and miss this? And I think it's a fair question. Like, people have been asking, why cut it so close? I told you this story, Pete, and I'll tell this to other people because it was a real learning lesson for me when I was 26. That was my second newsroom. And I was working on a really big story. It was a national story, a huge ash spill from the local power plant. It was like a volcano had gone off in East Tennessee and covered a bunch of homes. And I was put on that story. And, granted, I could point my finger at my bosses and say they gave me way too much to do in too short of amount of time. But I missed my deadline. I threw the whole show into disarray. The national correspondent that was waiting for NBC, she missed her, had to go first, and she was totally feathers ruffled. And so my boss got really mad at me. I'll never forget that day. So he not that I'm saying he acted appropriately or that that my reasons for, having run up against a deadline were not right. But he looked at me and he said, why did you file 5 minutes before the show? Because what happened was the computer broke. I had no control over that. I was filing my story 5 minutes before deadline. I would have made it if the computer hadn't broken, but the computer broke. I told him the computer broke. He said, well, why didn't you file 30 minutes ahead? Because if you filed 30 minutes ahead, you wouldn't have had this issue, because the computer breaks 30 minutes ahead. We have time to fix it. So anyway, I did miss deadlines after that. I got to admit it. It was not like I was perfect after that as a TV reporter, but I'll ask you that question, Pete. Why did we file so close to the deadline?
Yeah, I mean, it was just a couple of compounding factors. Our team is small. We're a nonprofit, so we're always balancing everything between what our current workload is, what we're trying to do. At the time, I was running for the state of Washington Attorney General, so obviously I wasn't fully in the right headspace. And my team is a very competent team, and I think just we got pounded with a bunch of deadlines that weren't expected simultaneously. And again, when we looked at it, we knew that, at least we believed in our heart of hearts, that filing when we did, which was even on a Columbus Day holiday, that we didn't see that as an issue. Obviously, it's one of those internal process things that I should have done a better job of tracking, of saying, hey, even if the statute of limitations is the 13th, the 14th, the 21st of October, let's file it by the 1st. That way we're in the clear. Unfortunately, I didn't do that. And so, I mean, it was a compounded interest as far as our current workload, my absence, and, just everything that was coming together, working on the declaration, working on the pleading, just making sure everything was perfect up kind of the last minute. And unfortunately, according to the judge, we pushed it beyond that. I still, you know, in my heart of hearts disagree, but I always say this, I wear a suit to court, not a black robe. And so my opinion only matters in the position of advocate, not as decision maker.
Okay, follow up. Thank you for the super chat, Viva Fry. Why did counsel even flirt with the statute of limitations in this case? Also, why were your lawyers not in front of a judge the next day begging to be relieved of default? Maybe you can explain what relieved of default means. I don't mean to sound like a jerk or a Monday morning quarterback, but clients are never supposed to suffer the consequences of the errors of their attorneys on procedural delays. I'll let you take that one, Pete.
Yeah, I mean, this is something we've hashed out. So I don't think that being in front of the court the next day would have changed the course of this case. I don't think so. So I don't see that would have been beneficial. And look, everyone's going to have their Monday morning quarterback opinion, and that's fine. We did everything we could to make sure this case was worked up. We worked, you know, hand in glove with you, and we were doing everything that we could. I mean, I know you and I have had this conversation. We don't have a really good answer as to why it ended up being pushed this far. It just, I mean, it's extremely unfortunate. It shouldn't have happened. And it's one of those things that we're going to keep pushing. I mean, I don't have a good answer to that.
Okay. Well, let's switch to something I know a little bit more about real fast before we go on with the rest of the case. Maybe there's a follow-up there. And on Rumble Locals, thank you for everybody who's watching there. I will say, if you guys go back and forth between Rockfin et al., I'm going to stop streaming on Rockfin. I got to do a separate video about this, but I just give everybody a heads up. I will not be streaming on Rockfin for the near future. They switched from the Ray, which is their cryptocurrency, to USDC, you know, our US digital currency, and they have a lot of money from a lot of us creators that now is totally defunct because it doesn't exist anymore. So anyway, until that's cleared up, I'm not going to be streaming on Rockfin anymore. They owe me some money. So anyway, I just throwing that out there. Don't watch on Rockfin. If you do, however, want to support the show and you have, like, you know, any interest in longevity for your life, maybe you're looking at the world today and you're thinking, I don't know, I don't want to extend my life anymore with cod liver fermented butter oil. But if you're still, you know, you're still in the game, go to greenpasture.org, promo code Allison, you'll get 10% off. They have a lot of great products. They've got natural muscle rubs, chest rubs, you know, if you're sick, ghee, coconut stuff. Like, but my favorite is the fermented cod liver oil, butter oil blend. It's fermented cod liver oil mixed with a high vitamin D butter oil, so cows out on spring grasses. And Dr. Weston Price, biological dentist, turn of the century, 20th century, notices patients were getting a lot of cavities from processed foods. That was his basically his idea was that malnutrition was causing it. And so he studied all these indigenous cultures around the world who did not have dental care, but they did not have cavities. And essentially the vitamins that he understood they were taking with organ meat and, you know, vitamin D sources, if they were mixed together, we now know, like with vitamin K, that allows you to absorb all of the vitamins. So that's why you don't just take a fermented cod liver oil or just a butter oil. You take them together, and then those vitamins in each allow your body to absorb the most. So I use this after chronic cavities. I stopped getting cavities. It's an amazing product, but it's also great for all kinds of stuff because it's really like, helps with anti-inflammation. It's got a bunch of omega-3s. And just like you're somebody who's got fibromyalgia, allergies, autoimmune disorders, that kind of thing, try it out. Let me know what you think. Go to greenpasture.org, promo code Allison. Check out what they've got. You will not be disappointed. Okay. Let's talk about sovereign immunity real fast. I take you back to the complaint and yeah, okay. So yeah, they say because amendment would be futile, Westover's claim should be dismissed with prejudice and judgment, which I never understand what this means, prejudice. Maybe you can explain that to me too. What does it mean to dismiss with prejudice? But what is sovereign immunity? Why do they say that they're protected? I shouldn't have been able to sue because they're protected by sovereign immunity.
Yeah, so I'll jump to prejudice really easy because that's a real quick question. Dismissing a case with or without prejudice means it's either fully terminated or there's an opportunity to revive it. So when a case is dismissed with prejudice, it's done to the point that they claim amendment is futile. There is no way to salvage the case. This is the full knockout punch. You're on the canvas. You're not getting up. Dismissing without prejudice means you're knocked out, but you're starting to get up, and you might be able to amend the complaint, and there may be a way to salvage a portion or all of the case. And so when a party or when a judge dismisses a case with prejudice, it's like your only option is appeal or let it go. And as you may recall, several of the claims were dismissed with prejudice, but then the whole name clearing statute was dismissed without prejudice, which is why Judge Cartwright gave us the opportunity to amend the complaint on that issue. So, in other words, amending the whole of the case would have been worthless, in her opinion. Futile would be another way to say it. But she salvaged that one issue, and again, dismissed that without prejudice, meaning, okay, you're on the revival process. As to sovereign immunity, the state, especially the state of Washington, believes that it really should never pay consequences, that the king, sovereign immunity is the crown is immune from any lawsuit. The crown will prevail, and thus the crown can do what it wants. And that's how the state of Washington tends to believe, or at least look in the mirror and see itself wearing the crown. It believes that sovereign immunity, we have several cases against them, in addition to the one that we brought on your behalf, several on free speech, several on other constitutional rights. And they believe that the Constitution and that sovereign immunity protect them from any damages. And it's a crazy notion that you have a government that'll run amok and just trash and thrash your rights and then say, mea culpa, no bad, or not even mea culpa, I'm the king, subjects bow to me.
All right. If you want to learn more about the cases that Pete's talking about, you go to silentmajorityfoundation.org. They've got First Amendment cases, Second Amendment cases, there's a bunch going on. And some of the doctors you've seen on the internet talking about censorship over the last few years are their clients. So silentmajorityfoundation.org. Okay. Somebody over on Locals asked, so do I understand you're not appealing? Yes. Okay. So basically, about missing the statute of limitation, does it out you at or put you at risk of sanctions? We explained this earlier, but if you're just joining the stream, the reason that I chose not to appeal the judge's decision on the statute of limitations is because Pete and his team advised me that I was likely to lose, and I was already facing tens of thousands of dollars potentially to pay back the state of Washington for their legal fees, which, by the way, the state pays. Okay. So here it is. They fired me from my job. So I lost my salary and, pension stuff. Well, maybe I could look at my, I don't know. I have to call them and see if I probably had like $10 in there. I don't think I wasn't there like a very, very long time. I was there a couple years, but I definitely lost my health insurance. So they did all that. I lost my salary, lost my health insurance. And then on top of it, thankfully, Pete and his team were taking my case on contingency. So I wasn't paying them anything unless we won. But on top of the fact that you pay taxes to Washington State and, the government screws you out of your rights, you have to usually pay an attorney to fight them. And then your tax dollars are paying for their attorney. And then they will ask you, the citizen, to pay back their attorney's fees, which taxpayers already paid. Isn't it a lovely system? It's an amazing system, right? So, look, they already screwed me out of my job and health insurance. It is not a stretch to say that if I still had a job, we would not have a mortgage. We probably would have been able to pay off our house. We definitely would have been able to get out of our car debt. So there are lots of things that, already it was like, well, we're, hunkering down financially to deal with the fact that I was unwilling to censor doctors. I didn't want to be in an even worse situation where now I was going to be in debt to the state of Washington for having to pay them $50,000 or more. They had me, I hate to say it, but I was stuck between a rock and a hard place. I really did not have, unless I'm missing something, unless there's some other option that I didn't hear about, it just sounded like, it was going to potentially be a situation where it was going to be even worse than when I got fired. Now I was not only out of a job potentially and like health insurance, I was going to be out tens of thousands of dollars in legal fees to their lawyers. So I don't know, Pete, you want to revisit that, or do you feel like I explained that all right?
You explained it well, and that's really the risk reward proposition. Is we felt like taking the case again. We believe there's merit to the case. The problem is the judge dismissed it on the statute of limitations thing. We didn't think that was an argument that was going to fly well before the Ninth Circuit because it's got some case law that cuts both ways, and obviously the judge determined that the case that cut against us was the most prevailing case. And again, whether we agree with it or not, we're not the decision makers. And so when it came down to it, trying to prevail over a judge who had determined that she was right, taking that before a Ninth Circuit panel of 3 judges just didn't seem like it was going to be the route to success. And to your point, there were attorney's fees from the trial court. There would be attorney's fees from the appellate courts. And so what we didn't want to do when we were discussing it with you is put you at further risk. And the question was, do we want to pursue this on an opportunity that we didn't see as the strongest opportunity, versus risking you? I mean, I think, quite frankly, had we gone through appeals, 50,000 probably would have scratched the surface on what they would have sought in their attorney's fees. I will tell you, I'm up against the same organization. They've got a $200,000 retainer on behalf of the city of Spokane. We've gone through 2 pleadings. We've got, well, a little bit more than that, like 3 pleadings. $200,000. They're asking for $250,000 in attorney's fees for discovery, is what they're claiming it's going to cost them. So to barely get to this stage, they're claiming it is going to cost their client $500,000. So God forbid that's where you and I end up on your behalf. We didn't want to take you there, because then we knew it wouldn't be a question of your car payment or your car debt. It'd be whether or not you were bankrupt. And ultimately, it just didn't seem like that was the best tenable position for you and your family.
Okay, over on locals, and this is another point I think people had some questions about too. Okay, Ginger Ninja, thanks for the tip. Sorry I missed the beginning of the stream. I can't help but think there was a bias that those robe wearers are grasping at anything and everything to shut this down. Washington is terrible. I hate that Pete was unsuccessful in his election as well. Yeah, we can talk to Pete about running for attorney general in a second. So yeah, there were, let me look up the other comment that was kind of like that while I'm asking you this question. There were people that, when I posted that this happened, asked people for questions ahead of time, which you can do if you are on my editorial board, AllisonMorrow.locals.com. It's a great way to support the show. It's $5 a month. I think it's far worth the value. Let's see here. Okay. Let's just scroll down just a smidge. There's a lot of comments here. It was basically like, Barnes taught me, educating me for several years. Robert Barnes has been educating me on for several years that when a court wants to avoid an issue, they will find any excuse to do so. Conversely, when they want to rule on a topic, they will write a new law to do so. I hope that you and your team find a way to appeal this. So the question from both of them is basically, was there political bias or in some way core corruption that you believe played into their decision to decide with the state's argument that we missed the statute of limitations, or was it a fair decision on her part?
I mean, look, I can't definitively say what happened behind closed doors, but I certainly don't think it was the right decision. I still disagree with it, and it still sits and I guess the old saying is sits in my craw, right? I don't know how edited we can say it. Really upsets me. I'll just say, just in case, I don't want to get in trouble with saying bad words here. But it's still disappointing whether or not there was a handshake behind the scene. I can't say that. I'm not living there. I will tell you, I like to be in certain parts of the state of Washington when I'm litigating. I mentioned the case in Spokane. It's very clear that some of those people, the same law firm that represented us, different partners, albeit, it's clear that they don't like being in Spokane County. And had we had the opportunity to take it somewhere else, and we talked about this early on, your residence versus where the state resides, could we take it out of the Western District of Washington? Because our other option in state court would have been Thurston County, which I do not like being there, and there are obvious reasons, and we could talk about that a whole nother show, a whole nother day. But yeah, it's frustrating when you go into these courts and it's like, are you freaking kidding me? You find the most narrow reading of the most narrow law and then dismiss a case that's about somebody's civil rights. But to the commenter's point, it feels like there are opportunities where they take the most expansive reading on even the most narrow point and find a way to wedge a case into victory. And it's frustrating to be on the side of right. And I don't mean that politically. I mean that, on the side, to your point, of what God protects us through the Constitution, and then you just get dismissed.
File and the Ninth Circuit, unlike Dems shopping their case. Oh, there's Pete. Did you hear what I said, Pete?
Yeah. So we would have had to be in the Ninth Circuit, which is why, to the point that we felt the appellate process just kind of would have been rinse and repeat. And it just, it was the sanity check. And again, we had to weigh that rinse and repeat effort versus, Allison's well-being and her financial well-being. Because as I mentioned, it wasn't just the $50,000 that we assumed they had racked up at the trial court. It would have been any costs for appealing. And last thing we wanted to do is take a good case that would have been a Hail Mary before Ninth Circuit and risk your financial future.
Okay, Pete. Let's see. There was one other question. Kenny, where are you here? I'm going to look this up. Okay. That really stinks, Kenny says over on Locals. My question is, what is the possibility of opening a class action lawsuit with as many litigants as possible for systemic suppression of the First Amendment? Also, have you thought of contacting Harmeet Dillon at the DOJ Civil Rights Division? It's a shot in the dark, but hey, why not? But I do believe it's like one of the other commenters wrote, vengeance belongs to the Lord. So what do you think? Class action lawsuit with as many litigants for systemic suppression of the First Amendment?
I mean, I'd love to see that. I think the only way you can have success is if the United States were to intervene on behalf of that case. I mean, that goes back to the whole crown is above everything else, the sovereign immunity here in Washington. That is a very successful tool for the state of Washington to absolve itself from any liability. So it's a road that's extremely uphill, if not just fraught with entire peril. As to bringing in the Department of Justice, I'm watching. I'm as vocal as I can be through social media to try to pull them in. I see a lot of stuff that I'm tagged in. As was mentioned, I ran for Attorney General, so I'm kind of a known quantity for the conservative thought here in Washington, and I see people trying to rope me and Harmeet and other DOJ attorneys together. And God willing, I saw that they just filed an amicus brief on behalf of Nick Rolovich, the former Wazoo head coach. More importantly, I saw that Ms. Dillon and the DOJ is taking on some of the civil rights issues related to voter integrity. I believe that's in California. So as I think things heat up here in Washington State, I think there is an opportunity to approach these civil rights issues through the Department of Justice. As to a class action, I don't know that you're going to have the right, what they call putative class or class members on just kind of a global suppression of speech. I think you're going to have real concretized injuries that would run concurrent with a class. And so that may be a bit difficult, but I do believe, I am hopeful at least, that the Trump DOJ administration will get actively engaged in Washington. And if that happens, I think that's going to change the temperature of all these civil rights issues. Don't forget, for those following along at home, we still do not have U.S. attorneys appointed in Western or Eastern District of Washington. So we are literally having to claw back to D.C. We have interim folks, but we don't have, Trump appointed folks here kind of representing us on behalf of the U.S. government, aside from some interim folks. So it's a real interesting question.
What is your biggest takeaway or biggest takeaways from running for Attorney General in Washington State?
There are some phenomenal people here in Washington. I'm extremely grateful for the support that I had. I think it's, there's two sides of me. One that feels like it's a lost cause. On the other hand, feels like it's revivable and it's winnable. I've seen, if anyone's paying attention, there's a guy named Shiloh Marks who's filing a bunch of stuff in California to pull off their dormant voters. And from what I saw, I think it was his report that indicated there were like 498,000 dormant voters. Now, I lost by about 410,000 votes. So if those dormant voters were in fact voting, and I'm not convinced that that can actually happen without pulling the people off the rolls. If that were to have happened, obviously there's a victory at hand. And what I want to say is not just the global for your executive races that are maybe 400, 350,000 votes apart. You know, if you start cleaning up the voter rolls onesie twosies, there was a gentleman, Brad Benton, who ran for state senate down towards Vancouver, southwestern Washington, lost by like some 117 votes. Imagine if you cleaned up 150 votes in that, you'd have one more Republican senator. There are two special Senate elections that are forthcoming this summer, this fall, that are actually winnable by the Republicans. Now you're changing the Senate by 3 seats in the state, and that's significant because you have 49 senators. So I guess the one thing I'd say is, yeah, it was a lot of work. It's frustrating to see how it ended. I was really looking forward to getting in and probably getting recalled by the left within a heartbeat. But I was going to do the right thing and at least hopefully forestall the evil of the left. And unfortunately, it didn't happen. And, you know, again, there are a lot of great people out there, and I appreciate your support. For anyone that's listening here that's been a supporter.
Pete, is there anything else that I did not ask you that you want to discuss?
No, I mean, look, it's been a tremendous pleasure working with you, and I'm so grateful for your advocacy, for open communication, for being willing to give people a platform that were silenced. You know, whether it's us or whether it's those doctors. I mean, your ability to communicate is critical. And I'm pissed. I'm frustrated. I don't like how this went down. And obviously, if there's a time machine, I change things. I don't have that. So if any listeners have that, let me know. We'll fix it. But you know, I mean, I'm grateful that you're continually out there speaking the truth. That's what we have to continually do. We have to. I mean, yeah, is it disappointing and frustrating? Absolutely. But we have to keep marching forward, because right now, to the question about the Harmy Dillon thing, we've got a president and the U.S. Department of Justice that will help us, but we still have to help ourselves to get there.
Yeah, and to your point, I still believe that the best way to protect the First Amendment in this country is to just keep talking. I think that the justice system obviously has its purpose. It's starting to look a lot less likely like a justice system, but the more people that keep talking, like the less need we'll have to go to court, because the less likely we'll get censored. Because you know, the ironic thing about what I saw during COVID was that there were so many people that were so scared to stand up that that meant that more people ended up suffering the consequences of these unconstitutional policies, because I really believe that the authorities during that time would have thought a lot better of their decision making if there had been more of us who were willing to take a stand and potentially, uh, you know, make the sacrifices for the consequences that would come. There were more, I think more people got hosed during it because there were so few people who are willing to get hosed. You know what I mean? So it was like one of those things. If you were willing to potentially take the risk, there actually would have been less risk for all of us, because there would have been more of us standing up against what was happening. So the more that we just keep talking, the less likely we're going to have consequences that require us to file a lawsuit, because there won't be actions taken against us that are unconstitutional and violate the First Amendment, because there's only so many people that, you can play whack-a-mole with. At some point you're going to give up and say, forget it. I'm not going to try to suppress all this speech, because there are just too many people talking. It's easy to do it when it's 5 people. It's a lot harder to do it when it's 5 million. So on one hand, this lawsuit has, it's ended in a way that I did not perceive. I know, like I said, a lot of people were like, well, it's Washington. What did you expect? I didn't expect this. I didn't expect this. I'm trying to let go of expectation with life. I think in some cases, a lot of our discontent comes from having some kind of expectation, but I'm trying to go with the flow. I will say I just did not expect this. On that note, though, I don't think it's as powerful as just continuing to talk. So even though the lawsuit may not have ended the way that I had hoped, I can still talk. So I'm just going to keep talking. That fight has not ended. So that continues, and I just encourage everybody else to continue with it. People are asking like, why is the state so quick to, it seems like anyway, more and more. I mean, maybe I'm 43, so I don't know. Maybe I missed it when I was in my 20s or my teens, but it does seems like more and more the state comes after people in a way that is unconstitutional, and then the onus is on us to fight back to prove that they're violating the law. In other words, I've always thought, like, why doesn't the government have to prove what they're doing is legal before they do it, instead of we have to prove that it's illegal when they do it? I mean, it just seems like it's not a fair fight. And it does seem like more and more we're starting to see that. And I really do believe that it's because in some cases we're allowing it. We're allowing it, not necessarily by not suing enough, but by just saying, no, you can't do that to me. You can't force me to act against my constitutional liberties. And I'm going to keep doing it, whether you fire me or not, or I have to move to a different state, or whatever the consequence is. And I have great empathy for people who, we're in very tough places. I'm not trying to judge anyone like, why didn't you stand up? I'm just saying, I think it's a true ratio that the more of us who just refuse to stop acting in our constitutional rights, the less likely our constitutional rights are going to be violated. So just keep talking. If you're concerned about the First Amendment, then just keep talking. And that's the best way to fight it. So that's my last word. Pete, you feel good? You got it all off your chest?
Yeah, I mean, I appreciate what you said there, and it goes back to that whole immunity thing. We bring not only First Amendment, but we got a lot of Second Amendment cases, and there have literally been legislators who, in a hearing, on a legislative hearing, I'm not talking about a court hearing, I'm talking about passing a bill, who are told affirmatively, you'll be sued and you're violating constitutional rights. And the response here in Washington is, file your suits. They know what they're doing is unconstitutional, but they've insulated themselves through legislative immunity, and that's a whole nother topic for another day, that protects them well. And in Washington, when I sue, they have these BS things called findings of fact, and it's how they tee up their legislation. And the legislature can BS its way through any political speech, adopt that, and then I have to go into court and disprove it. And to get a judge to say, hey, you're actually right, even though my facts are very clearly incorrect, specifically to the firearms issue, I have to go in and prove it. And then the judge has to say, well, the legislature adopted it. It's legislative facts. And it's like, again, I'm trying not to say, bad words here. It's total BS. It's leftist speech. And they get to be insulated from lying in our legislation. And that's, to your point, that's part of the broken system. But the more people that stand up and don't just call them out, but actually stand against them. And I'm not talking about anything violent. I'm talking about just standing up against them, rallying against them, and saying, no, we're not going to disobey this unconstitutional law. There's, to your point, there's either whack-a-mole with 5 people, there's whack-a-mole with 5 million people. And when your arms can't reach out as far and wide as it needs to cast that net, to play whack-a-mole, you're exhausted. Your resources are exhausted and you can't do a thing. And that's the problem. This is what we saw in COVID, whether it was with free speech. We saw school districts stand up, and there were a handful. And I always told them, listen, get a group of 30, 40, 50 school districts. They're not going to be able to not fund that many, but they can take your funding if there are 2 of you. And so that's the key. We, united we stand, divided we fall. And the question is, do we want to be a conquered people, or do we want to conquer and stand for what's right? And we have to continually be united. And so, God bless you for using your voice for good. Keep doing it. keep doing it. I'm pissed that our conversation here isn't, we crushed it because we were right. We were right. We are right. And it's infuriating. This is how it went down. But we'll keep grinding from the legal sense. You keep grinding with your voice, and God willing, we'll meet back up and keep on this and move the ball towards the side of righteousness.
Thank you, Pete. Appreciate it. Yeah, one last final comment. I work in Washington for the state. I voiced my disagreement with the COVID requirements with management to no avail. I didn't care if people got a vaccine or not. My second email had my social security number. I don't know what that is. Well, thank you for at least voicing your disagreement and telling people that, your management. More people had said something. Like I said, I think, Washington, California, places, Oregon. There are a few states, obviously. We didn't move to Florida. It kind of passed by the time we didn't move to Florida for that reason. But, I will say, I always wondered, because Florida is my home state, why Florida was leading the charge of we're not going to comply, because Floridians never really were the I didn't, when I grew up here, people just like to go to the beach and have a rum and Coke and call 4:30, 5 o'clock. And that's just but I realized that's kind of why they wouldn't do it, because they don't want to jump on anyone's bandwagon here. They just want to be kind of just want to go to the beach bar and leave me alone. And so they're just people are well, you have to wear a mask. They're screw you. I'm wearing a bikini. I'm going to the beach. I don't care what you say. I'm a Floridian. I just don't do that kind of thing. You can't get Floridians to jump on your bandwagon because they don't care. So anyway, it is a very different environment here. But thinking back on when I did this interview, for instance, with a hair salon owner in Texas, Texas was kind of known as a non-comply state, but she lived in Dallas, and in Dallas, they were complying. And so she was put in jail for keeping her hair salon open. And that taught me a lot about the microcosms of how this works and paying attention to local politics, because you can live in Texas, but if you live in Dallas or Washington, that showed me the difference too. I lived in Seattle for a little bit, and I lived in Spokane for a little bit. There are two very different places. They're on opposite sides of the state. And in Spokane, they weren't putting people in jail or, finding them or for whatever, keeping their business open and masking, because nobody was complying. I mean, not, nobody, but it were far fewer people that were complying with some of these crazy mandates in Spokane as they were in Seattle. And so you could live in Washington and live in Spokane and actually feel like you weren't living in Washington. But if you lived in Seattle, you definitely felt like you were living in Washington. So that's just another thing too, is, don't just pay attention to the governor or the presidential elections. Pay attention to who's on your city council, and be aware that they have quite a bit of control over what's going on. And you live in a little town that has people that are fighting for constitutional rights in your city council. You might be okay if your governor goes crazy. So that's just another thing that I learned too. I definitely could do a better job of paying attention to my local politics in that regard too. So. Okay, well, thanks, Pete. Thanks, everybody, for watching. Thanks for the support on all the different platforms. And don't forget to check out the sponsors. And I guess I will see you guys next time. Tomorrow, we're talking about the bird flu vaccine. So that should be interesting. And if you haven't subscribed to my Off-Gridish Living channel or found me on the other social media platforms, Facebook and Instagram, where I do a lot more farm content, you're into farm and food and that kind of thing, then go follow me over there. We'll see you guys next time.